16 ವರ್ಷದ ಒಳಗಿನ ಹೆಣ್ಣು ಮಗಳು ನನ್ನ ಸಮ್ಮತಿಯ ಮೇರೆಗೆ ಈ ಕ್ರಿಯೆ ನಡೆಯಿತು ಅಂತ ಹೇಳಿದ್ರೆ ಆವಾಗ ಏಜ್ ಆಫ್ ಡಿಸ್ಕ್ರಿಷನ್ ಅಂತ ಒಂದಿತ್ತು. ವಿವೇಚನಾ ಶಕ್ತಿ ಇರ್ತಿತ್ತು. ವಿವೇಚನಾ ಶಕ್ತಿ ಇದ್ದು ಆ ಕ್ರಿಯೆಯಿಂದ ಉಂಟಾಗಬಹುದಾದ ಸಾಧಕ ಬಾಧಕಗಳ ವಿಚಾರ ಬಗ್ಗೆ ತಿಳ್ಕೊಳ್ಳತಕ್ಕಂತ ಶಕ್ತಿ ಇರ್ತಿತ್ತು. ಹಾಗಾಗಿ ಅಂತ ಪ್ರಕರಣಗಳಲ್ಲಿ ಕೋರ್ಟ್ನವರು ಯಾವ ಮಾನದಂಡವನ್ನು ಅನುಸರಿಸಬೇಕು ಅಂತ ಹೇಳಿದ್ರು, ಫಾರ್ ದಿ ಪರ್ಪಸ್ ಆಫ್ ಗ್ರಾಂಟ್ ಆಫ್ ಬೇಲ್ ಆರ್ ಅದರ್ವೈಸ್. ಬಟ್ ಪೋಕ್ಸೋ ಆಕ್ಟ್ 2012 ಬಂದ್ಮೇಲೆ 2013 ಇದು ಅಮೆಂಡ್ಮೆಂಟ್ ಆಗಿದೆ, ಇನ್ ಕಾಂಪ್ಲಿಮೆಂಟರಿ ಟು ದಿ ಪೋಕ್ಸೋ ಆಕ್ಟ್. ಗೊತ್ತಾಯ್ತಲ್ಲ? ಅದಕ್ಕೆ ಪೂರಕವಾಗಿ, ಯಾವುದಕ್ಕೆ ಪೂರಕವಾಗಿ? ಪೋಕ್ಸೋ ಆಕ್ಟ್ ಗೆ ಪೂರಕವಾಗಿ IPC ನಲ್ಲಿ 375 ಸಿಕ್ಸ್ತ್ ಲೀನದಲ್ಲಿ ಕೊಡುವಾಗ ವಿತ್ ಆರ್ ವಿತೌಟ್ ಕನ್ಸೆಂಟ್ ವೆನ್ ಶಿ ಈಸ್ ಅಂಡರ್ ದಿ ಏಜ್ ಆಫ್ 18 ಇಯರ್ಸ್ ಅಂತ. 18 ವರ್ಷದ ಕೆಳಗಿನ ಹೆಣ್ಣು ಮಗಳಿಗೆ ಆಕೆ ಸಮ್ಮತಿ ಹೊಂದಿದ್ದಳು ಈ ಕ್ರಿಯೆಗೆ ಅಂತಂದ್ರೆ ಅದು ನಮ್ಗೆ ಉಪಯೋಗಕ್ಕೆ ಬರೋದಿಲ್ಲ. ಆದ್ರೂ ಕೂಡ ಅದು ಅತ್ಯಾಚಾರ ಎಂದು ಪರಿಗಣಿಸ್ಬೇಕು ಅಂತ ಸೆಕ್ಷನ್ನೇ ಹೇಳುತ್ತೆ. ಹೀಗಿದ್ಮೇಲೆ ಏನ್ ಮಾಡೋದು? ತಿಳಿತಲ್ಲ? ಎಸ್, ಬರ್ಕೊಳ್ಳಿ. ಹರ್ಡ್ ಸುಭಾಷ್ ಚಂದ್ರ ಬೋಸ್ ಅಂಡ್ ಲರ್ನಡ್ HGP. The present petition is filed under section 439 CRPC with the following prayer. First, brief facts of the case are as under. A complaint came to be lodged by Srimati Chandrakala, wife of Shankar, stating that her husband is eking out livelihood by doing centering work, and she has a daughter. They have a daughter by name. They have a daughter aged 14 years. They have two daughters aged 14 years and 12 years. First, the first daughter is the victim girl. First, on 31/5/2021, on inquiry, victim girl revealed that neighbor, bracketal accused and neighbor by name Raghu, bracketal accused and happily, had forcibly took the victim girl with him, and in the guise of love affair, and also with a promise to marry her, he had physical relationship with her. First, based on the complaint, Rajagopal Nagara Police Station registered a case in crime number 189/2021 for the offences punishable under section 366 capital A, 376 and section 6 of the POCSO Act, and filed charge sheet against the accused inter alia, arrested the accused and sent him to judicial custody. First, next para, attempt made by the petitioner to get him enlarged on bail was turned down by the learned special judge by order dated 26th October 2021 in semis number 7797 of 2021. First, thereafter, petitioner has approached this court. First, that counsel for the petitioner vehemently contended that the accused is innocent of the offences alleged against him. First, he further contended that accused is in custody since 8 months, and since the charge sheet is filed, continuation of the accused in judicial custody is no longer warranted. First, also contended that ಇನ್ನೇನಂತ ಕೇಳ್ತೀರಿ, the case of a love affair has been turned down, has been blown out of proportion by the parents of the victim girl, and a false case has been lodged against the petitioner herein and sought for grant of bail. First, per contra and HGP opposes the bail grounds vehemently. First, he contended that even assuming that there is a love affair between the victim girl and the accused, the forcible sexual intercourse would attract offence under section 6 of the POCSO Act, inasmuch as the alleged consent by the victim girl is no consent in the eye of law and sought for rejection of the bail petition. First, next para. In view of the rival contentions, this court heard the parties in view of the rival contentions, this court perused the material on record meticulously. First, admittedly, the victim girl is aged 14 years. First, following the dictum of the Honorable Apex Court in the case of independent thought versus so and so, the consent, if any, of the victim girl is immaterial, as the same is no consent in the eye of law. First, the provisions of section 29 and 30 of the POCSO Act cannot be lost sight of while appreciating the rival contentions of the parties. First, therefore, this court is of the considered opinion that the grounds urged in the petition are not having merit so as to enlarge the accused petitioner on bail. First, next para. However, having regard to the definite timeline prescribed under the POCSO Act, the trial needs to be expedited. First, therefore, this court is of the considered opinion that no grounds are that the petitioner is not entitled for grant of bail by resorting to the special powers vested in this court under section 439 CRPC. Accordingly, following order, petition dismissed. First, the trial court is directed to expedite the trial in view of the timeline prescribed under the POCSO Act.